executive. He is the head of the state. The office of governor is often in the news for various reasons, both for positive as well as negative news. An office which was supposed to be apolitical in nature has been in the news since past 70-75 years for the political reasons, because a special constitutional post, an independent post, governor has two roles to play. One, of course, he is head of the state. Another, he also acts as the agent of the center. Therefore, it is always a political positioning as well as interesting position, interesting space where the political activities will always imbue. The important aspect of the office of governor is always discussed vividly. However, in the purview of understanding the Indian Constitution and understanding the polity, the governor's office remains to be one of the important subject, important position, important office around which the politics, the governance and all the administrative aspects revolves around. The idea of governor, one can understand, one can realize the fact the position of governor was started with the Western concept. In India, especially, it was started by Britishers. We know the provinces like Madras, Bombay, Bengal, they were administered by governors, and these governors became subordinate to the Governor General, who was the direct agent of the crown. That is how the office of governor is evolved in India. It's a colonial legacy, it's a colonial continuity. The name suggests governor, nothing but he is a head of the province. Today, post independence, he is the nominal head of the state. Governor, one who governs. Wherever the British administration still exists, there remains the post called governor, governor general. One can see it in Canada, one can see it in United States of America, which is also existing in India. The idea of governor has been a very importantly understandable in the Indian political context as well as Indian administrative context. We had an option to do away with the post of governor or to change the nomenclature or name of the position. However, the constitution makers thought that it is better to continue with that name itself, as it is relevant to Indians and bureaucrats, as well as it is just a nominal executive, he won't be a real executive. Therefore, the office of governors will be in reality as a fountainhead of the state. However, in the real practicality, his proactiveness is, ideally speaking, should be less. Whenever we study the concept of president, parallelly we need to study the office of governor. President is head of the state, that is the head of the nation, whereas governor is head of certain states, certain provinces. So, while we discuss about the office of governor, we must understand there is also a position called as lieutenant governors, who are direct administrators of president. They are administrating the union territories on behalf of president. They are administrators. For example, Lieutenant Governor of Jammu and Kashmir, Puducherry, Lieutenant Governor of Delhi, they are directly answerable to the President. However, they are the direct agents of President. But when it comes to the Governor, even if he is an agent of the center, still he has to follow and abide by the suggestions of Council of Ministers. As I said, Governor's office is always in the news for various purposes, various reasons, political purposes. Today, it is again in the news. Supreme Court has given certain observations with respect to the governors of particular states for not taking the action to the bills passed by assembly, or rejecting, popularly we can say it, the rejecting the bills gone to him for his assent. And also, when I say the governor's office, it represents two items. A, he is head of the state, also he is the agent of the center. Therefore, his role is very clear, that he has to look after the welfare of the state. For example, Karnataka state's governor's role is to ensure the betterment of Karnataka state, the good governance is delivered, the state is upheld with good finances, the state is looked after by him in various prosperous ways. At the same time, he also acts as the agent of the center, in which he has to ensure that unity and integrity of this nation is always upheld. There is no secessionist tendencies. There is no separatist tendencies by the states. If there are any instances, he needs to suggest to the government or to the union government or to the president, stating that yes, this state is going against the very ethos, Article 1 of the Constitution, that is India, that is Bharat shall be union of states, which is going against this principle. Therefore, why government should not impose the president's rule and to remove the working government which is working against the interests of the state or against the nation. Let's directly get into the office of governor and try to understand the articles related to the office of governor, that is Article 1532, 167, which speaks widely about the powers of governor, how he is elected, the tenure, functions, roles, how he can be removed or how he submits the resignation, his importance in various fields like legislative field, judicial field, executive field, discretionary field, how he acts, what are his roles, everything we can discuss. Before that, let's get into the office of governor. Very broadly, let us understand, as I said, governor's position and office is derived from the colonial past. Britishers started this office. We have seen the observations like many past governors saying that it's like a golden cage and it doesn't have the real powers. It is just the nominal executive, just like the President of India, who enjoys all sorts of authority, whose signature is ultimate to decide any bill. However, in real polity, Prime Minister at the center and Chief Minister at the state remains to be the real executive of the state. Therefore, governor's office is, even though nominal, it has its own importance in the Indian polity, in the working of Indian Constitution. Article 1532, 167, which speaks the appointment of governor to all his roles, responsibilities, etc., etc. Governor's office, he is the head of the state as well as agent of the center. However, Supreme Court has time and again mentioned that he is not recruited by central. Office of the governor is an important office, yet it is independent and constitutional office. Therefore, he is not appointed, he is not subordinate. He is the independent entity. That is what Supreme Court has derived and analyzed and interpreted through the articles of constitution and various past proceedings and conventions. The governor's office is important in this regard. Let's understand how a governor is appointed. Who appoints the governor? The President of India appoints the governor. The Chief Justice of High Court preaches him the oath of affirmation, who dictates him. In the absence of Chief Justice of High Courts, there shall be senior most judges mentioned or delegated by the Chief Justice of High Courts. So, the governor is appointed by President of India, which is very important. He acts as the agent of the center, and President by his warrant and seal appoints the governor. He is said to be a nominee of central government. Independent constitutional office, as I said, Supreme Court has time and again derived. Earlier, there used to be one aspect that for a particular state, one governor will be appointed and that governor won't be appointed for another state. But post constitutional amendments, the conventions have been derived that a governor can be governor of two states also. In that capacities, his emoluments, his salaries will be shared by both the states. And there is no bar for the governor to become the governor of two states, because he is not the elected representative. He doesn't hold the office because of the majority in the Lok Sabha or majority in the assemblies. He holds the office during the pleasure of president. The convention is that usually a governor will be appointed for 5 years. He can be removed anytime, he can be transferred anytime. He cannot go and challenge it in the court of law. Even if he challenges, it doesn't fit, because the pleasure of the president remains paramount during the working or the tenure of the governor. There was a discussion in the draft constitution, there was a discussion whether the governors should be appointed like it happens in America, or let they be appointed. Either they should be elected like in case of America, or they should be appointed like it happens in Canada. In the draft constitution, it opined that let there be an option that governors be elected. But when the final draft came, or the final constitution was accepted, that provision was done away and the idea of appointment of governor was upheld for various reasons. One, he may become the parallel power center to what we called as the federal system, what we called as the elected representative system, parliamentary system. He will become the parallel force. Even if he starts contesting, it will be on his personal grounds or through the support of the elected government, which doesn't make any sense. A. B. He will become the parallel power center because he also gets elected. His positioning will also be remain strong because he thinks that even I got elected. CM and governor's power tussle may continue. And most importantly, there could be a conflict. However, to ensure that governors should remain a nominal head, not the real executive in a state, just like in case of Prime Minister and President, the real executive is the Prime Minister. In a same way, same parliamentary system, there should not be true real executives. There can only be one real executive and one nominal executive. That practice was followed even in the states. It may lead to the separatist tendencies, stating that, as I said earlier, because of his personal charisma or because of the support of ruling dispensation, a governor may win the election and he may start to give the warnings to the nation, warnings to the president, warnings to the central government, stating that my state, I won. We decide not to go with the idea of one India. These sorts of tendencies may grow. For that reason, the state or the constitution makers avoided this idea that there should not be election to the office of governor. Rather, president should appoint the governor. And most importantly, as I said earlier, if the president appoints the governor, there will be quite a possibility that president will have the control over the state, or center will have the control over the state, because governor acts as the agent. Whenever the directions of the center is not followed, or whenever the state goes beyond its capacities, goes beyond the unity and integrity of this nation, governor may suggest for the imposition of president's rule by overthrowing the sitting government. We have seen this misuse of emergency, the state emergency, Article 356 and 365. In past 70 years, many a times, many elected governments were dethroned. S.R. Bommai case is the benchmark case and most important case to understand how the center were misusing its power, misusing the office of governor and dethroning this elected state government, even when it had got majority, even when it was going under the ethos of India's constitution. It was morally right, it was politically correct. Even then, many governments were dethroned just because there was a change of governments at the center, or the same party was not ruling in the state. For petty reasons it used to happen. And of course, as I said, there creates a real crisis of leadership. Who is the real leader will be a question whenever the governor gets elected, even the CM gets elected. And for every time, CM has to run to the governor for taking the sanction of any bill, for appointments of state public commission members and head state finance commissions. For various reasons, he has to rush to the governor. And if governor gets elected, he may not abide by the basic principle, that is, governor should follow. What he should follow? He should just follow the advice tendered by Council of Ministers. He may disobey. Therefore, constitution makers believed that governor's office should not be elected, but it should be appointed. That's how we did not go for American model, but for the Canadian model. Even in America today, the governors gets elected. But in Canada, Governor General is same as the Viceroy. Governor General is same as the Mountbatten, who used to be the Governor General of India before independence. He appoints the governors in Canada. But in USA, governors gets elected. Okay, so what should be the qualification to be appointed as the governor? There are two primary qualifications. A, he should be a citizen of India. No outsiders is allowed to become the governor because it is the constitutional post, he is head of the state. Second, he should be having the age of 35 years. These are the two basic qualifications which are mentioned, which are followed. Rather than these two principles, some of the conventions are followed, because many commissions during the federal reformative commissions for the balance of federalism. Many commissions have suggested, given the reports, after which the conventions are being followed, that governor should be a apolitical person. He should neither be a member of any assembly nor he should be a member of any parliament, whether it is Rajya Sabha or Lok Sabha. He should be a political person. Many a times you see governor's post is like a retirement post to many of the political leaders who accomplish most of the positions when they are of their heydays, and once they get retired they get the positioning of governor. That is the followed principle in past 70 years. Again, he should be a political person. Many a times this principle is not followed, and when a governor is being appointed, he should be from outside the state. Therefore, he do not interfere in the politics of the state. He do not have any of the interest in this state. Profitable interest, office of profit, he should not have. Therefore, there is a convention that outsider is appointed as the governor of the state. Then there is one more aspect whenever the governor is being appointed for the smooth functioning of the administration. So this is the point. Tamil Nadu's governor, Kerala's governor, or other states' governor, wherever the non-BJP governments are there, the acquisition were made in the Supreme Court that these governors are acting as bottleneck. They are derailing our idea to bring about laws. They always reject our bills. They withhold without any reason. And they stop the real governance which should bring in a new change, new development. For example, DMK wants to bring in certain laws, whereas the Tamil Nadu governor, honorable governor, thinks that it is not right, or it may not be not in the good interest of the state. Therefore, he is not taking any action to the bills sent to him for the assent. This creates a kind of a power tussle. Therefore, the convention was very clear that whenever president appoints the governor, he should consult the CM of a state. I am appointing so and so person. There should not be any problem between you people. The two posts are important for the effective functioning of the state. Hence, we want the smooth functioning of democracy and development, a smooth functioning of federal balance and federal, development. Hence, we do not want any conflicts. With that idea, the convention was very clear. President needed to consult the particular chief minister and appoint the particular governors. But these are the conventions, they are unwritten and most of the times unfollowed. So what should be the conditions for governor's office? As I said, if he becomes the governor, all the emoluments, all the offices, all the house, no rent, perks, etc., etc. These are the common features for every constitutional offices. You can just relate it with the office of president. Whatever the president gets, governor gets at the state level. And of course, his salary, his emoluments, everything is determined by the parliament. And once when he is in the office, parliament cannot change according to its wills. The salary as of now is 3,50,000, and he has very important aspect. Whenever we speak of the office of governor, Article 153, whenever we speak of it, he has got the personal immunity, personal legal immunity, which is important aspect. Even the elected representatives have to a certain extent. Office of the governor and president in India have the legal immunity in two conditions. Whenever he is in the office, There cannot be any criminal proceedings held against him. Second, the civil proceedings can only be allowed after giving 2 months notice. Therefore, the time is given for him to reply. With malified intentions, there should not be any criminal proceedings or civil proceedings. Therefore, this liability is given to that position. Otherwise, every other person will come and say, okay, there was a governor's meeting or governor's program. During that program, something happened. Therefore, governor should be held responsible. He should be brought to the courts. Like this, there could be a chaos. To have the continuity in the governance structure, even if there is no elected government at the state level, the governor acts as the continuity. He acts as the continuous governance system, wherein the administration, day-to-day administration will be carried on, irrespective of the elected government. And as I said that criminal proceedings cannot be held during his office. He is governed or administered the oath by High Court Justice, Chief Justice of the High Court, or in his absence, Chief Justice of High Court will allocate some of the senior most judges to administer the oath to the President. Before entering into office, the governor has to make and subscribe the oath. The oath of the governor is most important because often at times this question has been asked. 2 to 3 points in this regard is important. One, whenever he takes the oath, he will say that I will faithfully execute the office. Then, just like the president, president is also entitled to defend the constitution, protect the constitution, preserve the constitution. Just like that, governor needs to protect, preserve and defend the constitution. Final interpreter of the constitution is Supreme Court. Whenever this question comes, keep this aspect in your mind. But whose responsibility it is to preserve, protect and defend the constitution? It is the constitutional post like president at the center and governor at the state. So, and the third important aspect whenever the oath is taken, to devote himself to the service and well-being of the people of the state. He needs to devote himself, not just become the, enjoy the office, enjoy the position. No, it is not his role. He takes the oath that the well-being of the people of the state is upheld by the governor. Therefore, it is very clear, sometimes even if the governor goes against the decision of the council of minister, he has to defend himself that these bills, these legislations, these actions are going against the interest of the people, are going against the well-being of the people. Simply because governor doesn't speak like any of the political members, it doesn't mean that governor do not have any responsibility. The freedom to express must be given to the governor's office, and also even in the Supreme Court, he should ensure the real reason behind obstructing the probable malified intents behind those bills. Often a time, I have seen Honorable Muhammad Arif Khan, the governor of Kerala, speaking against certain bills which he thinks that may bring about a chaos, whether it was in the education system, when the Kerala government wanted to bring in some sort of reformation or some sort of changes in the education curriculum. He openly protested. R.N. Ravi, the Honorable Governor of Tamil Nadu, he protested against the very word. It was presented during the budget session, I believe, or the first session of the Tamil Nadu government recently, which stated that we follow the Dravidian model of governance, to which R.N. Ravi, who was supposed to read that speech because it is his government, he denied, he debunked, or he just removed that word, thinking this form of government is nowhere mentioned in the constitution, or this new pattern is not to be mentioned or not to be legitimated. Therefore, he denied to read that statement because he may have thought that is in the best interest of unity and integrity of India. The term of the governor's office, usually it is a 5-year. However, the pleasure of the government, pleasure of the president matters. Pleasure of the president, whenever the office of governor comes, this point should be remembered. That does not mean that he cannot remove. That does not mean that post 5 years he cannot be reappointed. Reappointment possibility is there. A governor can be a governor of 2 or more states. This possibility is there. He can be removed much before his term ends because it is the pleasure of the president. He is not elected. These things are there. When the VP Singh government came in 1989, VP Singh asked, as the Prime Minister, his government, he asked all the governors to step down because those governors were appointed by the previous governments and they do not hold to be fit to continue in the office. Half of them resigned and rest of them were allowed to continue. The same thing happened when the P.V. Narasimha Rao government came. He said non-Congress government was there, so they appointed the governors. Now we have come, you do not have the authority to continue, hence you resign. That was the mandate, that was the order given to the governors. Most of the times there is a trick. In recent times they will not ask you to resign, they will just transfer you to some of the northeastern states. That also means that your term has finished. You cannot go and challenge in the court of law because you are appointed. You are not elected. You do not deserve any authority. Whole of your authority as the agent of the center as well as head of the state remains under the purview of pleasure of the president. Therefore, if you want to remove someone, you just transfer to the northeast. With this embarrassment, they will either resign or they will just subtly continue the remaining part of their tenure as the governor of that particular state. President may transfer. President can make such provisions for the discharge, effective discharge of the functions of the governor. President may, from time to time, he can say how to discharge, what are the rules to be followed, what are the patterns, what to do, what not to do. The administrative functionalities can be changed from time to time by the president with respect to governor. You remember this aspect. Between the state government and the governor, how the functionalities can be, discharge of the functions, how they can do, who will decide? Again, in that scenario, governor can decide how the meetings needs to be held, how the communication needs to be done. Whenever there is a need for the governor, he thinks some of the decisions or some of the developments of a minister, all the communications, he can ask this chief minister, who is head of the council of minister, to explain about those things or to give all the report regarding any new bills coming, any new discussion happening about any particular portfolios, ministries. He can ask the informations. But whenever it is about the discharge of functions, president may decide about the governors. If there is no governor, let's say in the circumstantial situations, extreme situations, let's say new government comes and the governor gets transferred and there is no appointment of the governor to that particular state, but a for the effective and continuous functioning of administration and the state, there requires a governor. During such instances, President may ask the Chief Justice of the High Court to act as an governor of a state. The same principles are followed whenever there is a vacuum, whenever there is a vacancy. That president post is vacant, Vice President acts as the president. Even when there is no Vice President, the Chief Justice of India is asked or will act as the president until a new president is elected. The same way, Chief Justice of High Court will continue or act as the governor, acting governor, until that time a new governor is appointed or a governor of a particular state is deputed as the additional in charge to that particular state. So then, what are the powers and functions of a governor? It is the most important thing whenever we have discussed broadly about the governor's office and everything. But ultimately, it is his powers and functions which will validate his office, which will determine how powerful the office of governor is. It will tell us the importance or the objectivity or the necessity of the office of governor. Just like the president has the diplomatic powers, military powers, which governor do not enjoy. As we know, it is a federal form, unitary nature government, wherein union government will have those powers and capacities. And when I say those powers and capacities, as the head of the state, president will enjoy those diplomatic powers and military powers. Governor will never have, no governor, no lieutenant governor will ever enjoy this sort of power. However, apart from these two functions, most of the similar functions are very parallel or similar to the president. Executive, legislative, judicial, then the financial. The four topmost aspects we should see, or under four umbrellas, we can see the powers and functions of the governor. The executive powers. When I say executive, in Kannada we say no Karyanga. In Hindi we say Karyanga. That is the real entity which executes. The government is nothing but the executive. Just like in the center, all the actions, all the executive actions of the government, just like in the center, are taken in the name of president. Even in the states, all the executive actions are taken in the name of governor. He make rules for the specifying, as I said earlier, the manner in which, how to function, how to govern, the orders and instruments, how followed. All these things will be made by the governor. As the executive head, everything is under him. Governor appoints, governor speaks, governor comes and says, this is my government. That is how it works. After the elections, governor will appoint or he will invite the parties having the majority to prove their majority. Before that, with the number games, one who has crossed the simple majority, governor invites them to form the government. Like that way, governor appoints the chief minister. One who has got the majority, he will take the applications of those that majority party. Then he will appoint the chief minister. On the advice of chief minister, the rest of the council of ministers are appointed. First, governor appoints the CM. CM will recommend who should be part and parcel of his council of minister. And to the CM as well as to the council of minister, governor administers the oath. And also, these Chief Minister and the Council of Ministers, that is the elected government, will be in the office during the pleasure of the governor. That means this pleasure of the governor is in the broad connotation. One must understand they will continue to be in the office as long as they enjoy the majority in the well of the house. A. B. They continue to hold the office during the fixed tenure of 5 years, beyond which there shall be a president's rule if there is no possibility of conducting the elections, or else there is a extreme situation wherein, for example, tomorrow center wants to bring in one nation, one election law, but most of the governments either have completed 5 years and they still have 1 year to go before the general elections. In that case, center through the parliament can make laws and amend the constitution by stating that let them continue for 1 more year, and let them continue for 1 more year. That law, if it is implemented, only in that extreme situations the governments can continue to hold office beyond the tenure of 5 years. If not, the president's rule will be implemented under Article 356. Ruling government will be dethroned until such time or before next 6 months when the situation is right to conduct the elections. Under Schedule 5 of the Constitution, there is a special right or special powers given to the governor to establish what is called as tribal welfare ministers, especially in the states. Whenever I say Schedule 5, it is about the tribal areas in the states, that is central Indian states, Madhya Pradesh, Jharkhand, Chhattisgarh and Orissa. In these states, governor appoints or ensures that there is a tribal welfare minister. Schedule 6 is about the provision of hill and tribal regions, Assam, Meghalaya, Tripura, Manipur. If you know the constitution, if you have read the constitution, you can relate to what I am trying to say. But in this case, governor ensures that there is a tribal welfare minister. Earlier there was this provision for Bihar, but in the 94th Constitutional Amendment Act in the year 2006, this provision was removed for the Bihar, but Madhya Pradesh, Chhattisgarh, Jharkhand and Orissa, in these 4 states, there is a mandatory that governor ensures that there is a tribal welfare minister. And when I say the state executive consists of governor, chief minister, council of minister and advocate general of the state. If I say executive, union executive, central executive, each consists of president, prime minister, council of ministers and advocate general. So, attorney general at the center, who is part and parcel of the central executive, and advocate general at the state level, who is part and parcel of the executive. Who appoints the advocate general? Advocate general holds the office during the pleasure of the governor or the government. He is appointed by the governor under Article 165. Similar way, Attorney General is appointed by the President and he holds the office during the pleasure of the President. That is a constitutional post. Even this Advocate General, who is the first law officer of the government, who represents the government, who can come to the assembly and talk about any of the law, legal aspects, he is appointed by the government. He is a constitutional post. Then he appoints the state election commissioners. State election commissioners are different from chief election commissioners or the election commissioners appointed by the chief election commissioners. State election commissions commissioners have the important functions to look after the elections for local bodies, that is 73rd and 74th Constitutional Amendment Act, which includes local bodies, panchayats and municipalities. Panchayats in the rural level, municipalities in the urban domain. To conduct, to determine, to delimit, there needs to be a state election commission, and that commissioner is appointed by the governor, and also governor will decide the tenure and service condition of the state election commissioner. But he is appointed by the governor, but he can be removed only just like the High Court judges are removed. How the High Court judges are removed, that's an important concept altogether. The High Court judges, if they are found guilty, they are, their conduct will be discussed during the Judges Enquiry Act. There shall be an enquiry commission appointed. A kind of a impeachment motion goes through, and when everything gets finalized, if the person is found guilty, he can be removed. Judges Enquiry Act speaks about this aspect. Before submitting something to the parliament, how many members should sign and give it to either the speaker or to the chairman of Rajya Sabha. Similarly, appointment can be done by the governor, but removal can be done by the president. Don't forget this. Similarly, governor appoints the members and the president of state public service commissions. But again, the removal can only be done through or done by the President of India. He appoints the chairman and members of State Public Service Commission, as I said earlier. He can seek any information relating to the administration of the affair of the state and proposals for legislation from Chief Minister. As I said earlier, any proposal is coming, any new legislation is coming, he can seek the information at any point of time. He needs to, or governor may seek the information, he needs to be updated. If the new legislation is being processed, being deliberated beforehand, he needs the information, hence it's a duty of the Chief Minister to give him the proper information from time to time. Remember this, whenever a money bill is introduced, that we can discuss in the financial aspect broadly, now we are discussing at the executive level, it needs to come from the or prior recommendation of the governor itself. He can recommend the most important aspect. See, remember, whenever we speak of governor, he plays a key role while inviting the majority members to form the government. Gives the time for the floor test, which is also very important aspect. Otherwise, most of the times, because of his discretions, many may not get the first hand chance and others may get the chance. This will create a new opportunity for the new governments to be formed. A new money bill, if it needs to be introduced, it is only through the prior recommendation, prior approval of the governor itself. Similarly, if the government, state government, two ways, right? Under Article 356, if the state government is not carried according to the constitution, for example, in the Bommai case, SR Bommai case, Supreme Court has held secularism as the ground to remove the elected government. If it is not following the policy of secularism, then it can be removed. That is what it has said. Same way, if certain aspects, basic structures are not being followed, the constitutional ethos, constitutional articles, constitutional matters, whatever the constitution has mentioned, if the state governments fail to follow it, in that case, under Article 356, governor may recommend to the president stating that so and so state government is not following, not abiding, not going according to the constitutional spirit, not carried away under the provision of constitution, hence it can be removed. And the recommendation of the governor is required but not mandatory. Sometimes governor may not give the recommendation even after center seeking that, for example, Tamil Nadu, Dravida form of government, which is not according to the very framework of constitution. Honorable Governor Ravi may not have sent the recommendation to the center seeking that they are not going as per the constitution, so please remove them or impose the president rule under Article 356. He may not have recommended. Even if he has recommended, it may not be politically wise for the center to impose the president's rule on the sole recommendation, because people may re-elect them again with thumping majority, which will be a setback, which will be a slap on the decision of the center. Or the Tamil Nadu government can go to the Supreme Court challenging the decision of the government, decision of the center, or the suggestion of the governor. In that case, there can be a face down if there is no strong reason for the center to impose a president's rule. However, during such cases under Article 356, governor may recommend, but the recommendation of the governor is not mandatory. Even without the recommendation of the governor, president may impose the president's rule in certain state because of the collapse of the constitution. And the second provision for the president's rule is very simple, in which the governor's activity or governor's involvement is not needed. A center sends an instruction to the state saying that Swachh Bharat mission be implemented because it is the necessity. Let there be vaccination throughout the state against the COVID. Center says it is a time that the enemy states are attacking, or we are under the financial stress. All your finances should be curbed. Expenditure must be curbed. In all such cases, whenever the center directs something to the state and state fails to abide by that directions, in that case, center may impose the presidential rule under Article 365. One is 356, another is 365. 365 is for center giving some instruction, state not following it. Finally, we all know, we call it Kuladipati. We say he is the chancellor for all the state universities. Governor acts as the chancellor, and he is the person who also appoints the vice chancellor to universities. These are the broad functions. Legislative power, similar to the president. President will do the same thing in the parliament. Governor will do those functions in the state or with respect to assemblies. Remember this. President's powers at the parliament, because he is also a part of the parliament. He is part of the government. He is part of the parliament. Because all the legislations, bills, when it gets passed by both the houses at the parliamentary level, Lok Sabha and Rajya Sabha, finally president will give the assent. Only then it will become the act. For that presidential assent, the recommendation of the Council of Ministers become the base. Similarly, in the state government, assemblies have become the primary source where the legislations are framed. Of course, ordinance making power that we will discuss in a while. In most of the states, there is no council, legislative councils are not there, just like the Rajya Sabha. Assemblies are paramount in the state, single house. So, whatever the bills passed by the assemblies, finally it will become act only if the governor gives the ratification assent. Otherwise, in certain cases, he may transfer certain bills to the center or to the president, and when he transfers certain bills to the president, the presidential assent or his decision will become the ultimate aspect. Since then, the governor's hold on that bill end right away. Chalo. He is an integral part of the state legislature. Now, what are the powers and functions? I broadly say SPADO, I call it. I used to, make that small acronym to understand. First, he will summon, he will prorogue, he will dissolve the house. He will summon winter session. Governor has summoned all the members for the winter session, budget session, monsoon session. We all know that between the sessions, Constitution says there should not be a gap of 6 months. There is no specific mentioning that there will be budget session, there will be monsoon. No, it will never say. There should not be gap of more than 6 months between two sessions. That is what Constitution says. The role of a governor is to invite, summon the houses. When the businesses are done, Speaker says, sign a dine, or Speaker says, the particular session is stopped. But the session will be prorogued only by the governor. He summons, he ends. When the term ends, 5-year term ends, when he thinks fit that, okay, assembly must go for the elections, then he will dissolve the assembly. The day when he dissolves, every representative, every MLA loses his positioning of MLA-ship. Summon, prorogue and dissolve. Then he addresses the assemblies. Firstly, during the new session, whenever the new elections are done, the assemblies are to be beginning or at the first session of every new government or new assembly. He will address A. B. He will address the session during every year, the first session of every year. Normally during the budget sessions, we see that governor coming and speaking up, saying, my government has done this, because he is the part and parcel of the executive, he is the part and parcel of the government, he is part and parcel of the assembly. Therefore, he comes up and says, he addresses. The address of the governor is paramount, is very important, because all the policies of the government will be expressed in the well of the house. If there are council, in the joint session, he will address. Otherwise, in the single session, that is in the single assemblies, he will come and address. The governor's address has its own importance since even before the independence. He sent messages to the house whenever the house is not working properly, whenever there is a chaos, when the meeting is not possible, quorum is not coming. During such times, he can send the message to the house by stating, you are going out of the zones, you are going against the laws, you are again going against the people's mandate. So he gives the messages what to do, what not to do, how much more time is left to end the bills, the proceedings, the businesses, or to say that how much money is being spent. These messages will always ignite a sense of responsibility among the members to conduct in a more disciplined, more accountable and more credible ways. He appoints the speaker. Remember, any member of the elected person, through election he may get appointed as the speaker, but governor appoints the speaker and also he appoints the deputy speaker. When the both speaker and deputy speaker, the offices fall vacant, he may appoint any of the senior most members to preside over the office of the speaker or deputy speaker. Precisely speaking, it is the speaker, because deputy speaker do not have the actual authority like that of the speaker. And same way it is also true and similar in case of councils, that is the upper house. He nominates 1/6 members of the state legislative council from amongst the persons having special knowledge in the art, literature, music, sports, social service, etc., etc. We know the composition of legislative councils: 1/3 directly elected, 1/3 are elected from the elected representatives or from the assemblies. Similarly, 1/10, I believe, they are elected through teachers' constituencies, graduates' constituencies, municipal bodies. Then there comes a provision to appoint 1/6 of the members of the legislative council are directly appointed by the governor. In Karnataka, we have assembly as well as council. For example, if I have to name one person, H. Vishwanath, who was a political person who used to contest the elections. Upon shifting from one party to another, he decides not to contest or he gets defeated. That is the most important aspect. But because of its contribution to the literature, how it can be, used, I don't know. He gets appointed under this provision. 1/6 of the members, H. Vishwanath, gets appointed by the governor. Earlier, there used to be a provision for the president to nominate 2 members from the Anglo-Indian community, as well as a single person from governor could appoint 1 person from the Anglo-Indian community to the state assemblies. Now, that provision has been removed by Narendra Modi government under article or under 104th Constitutional Amendment Act, which removed the unnecessary appointment of Anglo-Indians to assemblies and parliaments. Practically, they did not have any contribution to provide, for the simple reason why we should continue Anglo-Indians. We need only Indians for their representation, for their welfare, for their wives. No, that is the colonial continuity. We were trying to, continue with that such kind of appointments, which was not needed. To be more India-centric, the decision was very right. If they are still an Anglo-Indians, let them become the part and parcel of this land and shun away that identity of Anglo-Indians. Therefore, there cannot be any, disparities. Constitution doesn't provide any disparities. State doesn't allow for such disparities. Even the society has broadly accepted them, and there is no question of it. He decides the question of disqualification of members of the state legislature in consultation with election commission. It's about the defection. Who will decide about the defection? It is the speaker. But apart from the defection, 10th schedule of the constitution, anti-defection law, we know speaker will have the authority to say a member is disqualified or not. But apart from the disqualification under the pakshantara, under the defection, apart from that, there are other provisions like election malpractices, his criminal background, doing away of his winnability, his other activities which can be challenged in the court of laws. If a person has done booth rigging, malpractices, any individual can go to the high court, respective high court, against the winningness or election of that particular elected member. All such steps, governor will take a call on the defection or the disqualification of an elected member, but with the prior recommendation or prior consultation of election commission, to know the rules, to know the procedure, and to have a balance of electoral parliamentary system. When a bill is sent to the governor, after it is passed by the state legislature, as I said, we are speaking of the legislative functions still. A bill is passed, both the houses or one house will pass, it will be sent to the governor. If it is not a money bill, because during the money bill he has to give the assent, then it will become an act. Or else, otherwise, he has the three circumstances, three options. Either he may withhold the bill by not taking the action. In the cases of Kerala governor, Tamil Nadu governor, the allegations by those ruling governments are such that they are not taking any actions to our bills. A, they can do that. B, they can give the assent, then it will become an act. Or, in the third case, he can return the bill for the reconsideration if it is not a money bill, because money bill is or will come to the assembly with the prior permission of the governor itself. But if he sends back the bill to the assembly, just in case of president doing the same thing to the parliament, when they repass the bill, president has to give the assent. Similarly, governor has to give the assent. These are the three aspects a governor can act. There is a fourth, one more aspect, one more power which president do not have, but governor has it. What he can do is, whenever some acts are brought in, some laws are brought in, which will endanger the existence of high court, particular high court, which may harm the sanctity of the high court, or which may be against the national interest, outside the purview of the state, which governor thinks by bringing this law, it may create a tension in the unity and integrity of this nation, or against the very principles of one nation. All such laws can be transferred to the president. Once the governor transfers all the laws to the president, now the ball is in the court of president. He may take the action, or he may send it back, the bill, to the assembly for the reconsideration. But even in the second time, assembly thinks that no, president knows nothing. President means Central Council of Ministers, because president acts on the aid and advice of the central government, Central Council of Ministers. If the state government thinks that it is doing vendetta. President knows nothing. We are doing in the best interest of the state. Hence again, we will not change the nomenclature, we will not change the language, we will not change any clause. We will pass the same bill again and send it to the president. President may give the assent or may not give the assent. Very simple. And during this procedure, governor has relieved himself by sending the bill to the president. Henceforth, there is no need for the president to worry. Of course, as I said, those bills which he may transfer to the president are like the larger interest of the country, grave national importance, and dealing with the compulsory acquisition of property under Article 31A of the Constitution. Then the bills which are opposing to the directive principles of state policy, Part 4 of the Constitution, directives given by the Constitution to the states, including to the central government. And those bills which are against, which governor thinks they are against the ultra vires to the Constitution or against the principle or against the provisions of the Constitution. When I say legislative power, just like the president has, governor too has the function of promulgation of ordinances, ordinance making power, Article 1, 2, 3, it is for the president. Similarly, even the governor can promulgate the ordinances. They are not parallel to the legislative powers. They are not parallel. They only come when the assemblies are not in session, when there is a necessity, emergency. If I do not bring in this ordinance, tomorrow there could be huge chaos, crisis, existential threat. Therefore, it is necessity for me to bring in the ordinance. When he thinks that to be true, that to be necessity, on the advice of Council of Ministers. Remember, we oftentimes say the discretion of the governor, discretion of the president. Always remember, there is no such thing called as discretion in real parlance, in reality. Of course, there are discretions, but that discretion will be there just like a pocket veto, not taking any action to the any of the bills, suspensive veto we call it, by the president, or the real discretions comes when elections are held. There is no majority, and that is the time when governor or the president has the discretion to invite somebody to form the government. These are the very small instances, very rare instances where in reality or really the discretion of the Rashtrapati will work, president will work, governor will work. Otherwise, there is no such thing called as discretion of the governor in reality. They always need to act on the aid and advice of the Council of Ministers. That's why many critics call the officers of governor and the president as the rubber stamps. They are nominal, yes, but they do not have the real capacity, real powers to do whatever they want to do. Forget president, governor, at the end of the day, he is the agent of the center. Even if he wishes to do something beyond the capacity of the State Council of Ministers recommendation, he can't do, because tomorrow he is there in the office until the pleasure of the president. He is answerable to the union government, union home ministry. He needs to answer to the president. Therefore, he cannot take extravaganza actions. He cannot go beyond his limits. Then, when I say ordinance, he can promulgate the ordinance. Not during, when there is assembly, he cannot. When there is an assembly session, he cannot. Only during the emergencies. It is not the parallel to law making power of the assembly, but when the ordinance is passed, it will remain effective for 6 months, or as soon as the assembly starts, new assembly starts, within 6 weeks it needs to get ratified by the assembly, otherwise that ordinance will fall ineffective. Or due to extreme situations, due to the situations which are out of control, he need to re-promulgate the ordinance. In Bihar, the governor during Lalu Prasad tenures, I believe, governor used to re-promulgate the ordinance each and every time for many years. None of them used to go to the assembly for ratification. None of them were introduced. It was clearly against the very principle of constitution, against the very principle of ordinance making power. But that's how these provisions were misused. The ordinance were made to die and the ordinance were re-promulgated without changing even a word of it. And that was clear breach, clear misuse and travesty of constitutionalism in India by certain governments, certain parties. This is the most important legislative power of the governor, the ordinance making power. Then whenever he appoints state finance commission every 5th year to check, to know the financial health of the municipalities and panchayats. That is the most important financial power which the governor has. However, state finance commission, state public service commission, state election commission, these commissions on the yearly basis, or let's say finance commission every 5th year, submits the report to the governor. Governor lays down those reports in the assembly. No other member will lays. No member will have the authority to lay down, but only with the prior sanction or the treasury bench members, that is the elected government's ministers, may lay down on behalf of the governor, but in words it is very clear that governor lays down these reports in the assembly. Financial powers. Finance is most important aspect of any government. Without finance, nothing works. Always we say no. Polity is the guardian of economy. All this constitution, everything is there to guard the real power, that is the economy. Economy is the real wealth. Without this economy, there is no proper functioning of any government. Nothing is possible. And when we say the financial powers, it is the basic power of any government. That's why as soon as the government comes, as soon as the new financial year begins, the budget is laid down in the house to get the approval of the assembly for the next 1 year's expenditure, for the next 1 year's revenue collection and everything. So when I say governor addresses the session, joint session or session, during that time governor says it is my government. At the same time, when the budget is there, budget is actually presented by the governor. On the behalf of governor, finance minister lays down the budget. A beautiful concept which will be ideological, but in practicality governor may not have any sense of that budget at all. It is only after the presentation of budget, governor may be submitted with a copy of it. by the governments. However, it is the custom which we say governor presents the budget, lays down the budget, state budget. It is the same way president lays down the budget of the union. Money bills can be introduced even in the center, even in the state. Money bills can only be introduced with the prior recommendation, with the prior permission of the governor. That's why with that permission, when you lay down in the house, when it gets passed, if you know that money bills are decided as the money bills, that authority is given only to the speaker at union level. Only the Lok Sabha speaker will decide whether it is a money bill or not. Similarly, in the state assembly, money bills are introduced with the prior recommendation of governor. When the speaker gives the yes or certifies that this is a money bill, this thing can be passed and governor won't reject for the simple reason it came through him. No demand for grant can be made except on his recommendation. A new demand for grant can only be made through or by the recommendation of the governor, otherwise it is not possible. He can make advances out of contingency fund of India for emergency circumstances. Who can make it? Finance secretary will make it, but the permission by whom? That is the governor who gives the permission. He constitutes the finance commission to check the health of municipalities, panchayats every 5th year. So he appoints the state finance commission every 5th year. The union finance commissions are for the lateral, horizontal and vertical devolution. It is appointed by the president under article 280. Similarly, under 73rd and 74th Constitutional Amendment Act, the provision was made in the constitution for the governors to appoint the state finance commissions every 5th year to study the health of panchayats and municipalities, the financial health of those local bodies. Then finally, the judicial powers of the governor, which are very important. Remember, even the president enjoys the judicial power. He enjoys topmost judicial power. During the capital punishments, it is the president is the only authority who can pardon. Even the capital punishments cannot be pardoned by the governor. That is one of the exceptional condition which president has. And president enjoys, he has no boundary except throughout the India. But governor has the boundary which is limited to his state, and he can enjoy his judicial powers which are restricted or which are done by the state governments, state laws. That is the only limitation. Apart from that, by and large, whether it is giving the reprivation, pardoning, or reducing the sentence, or giving the alternative sentence to a particular person who is undergoing the punishment, who has been guaranteed the punishment by the courts. So let's see judicial powers. He can grant pardons, reprieve, respites and remissions of punishment, or suspend, remit and commute the sentence of any person convicted of any offence against any law relating to the matter to which executive power of the state extends. As I said earlier, executive power of the state extends. In that purview, only then he can commute, he can lessen, he can say, okay, you have gone through so many hurdles, so many this thing, because of your good behavior or because of your past, that there is the request has come that you be pardoned from death penalty, you be relieved from life sentence, your punishment may be reduced by so and so years, or you are going harsh punishments, you are undergoing harsh punishment, so let me transfer you to from this punishment to this punishment. These things commute, reprieve, respite, these powers are there, but how much is there, how much he can enjoy relating to the matter to which the executive power of the state extends, not beyond that. He cannot go and give the pardon, he cannot give the reprieve to Karnataka governor, cannot go and reprieve to Telangana guy unless he is the acting governor to Telangana. That is the twist in this. But in case of president, throughout the India, throughout the any cases, even the military cases sometimes, in the exceptional cases, he can take up a call. He has the authority to do so. He is consulted by the president while appointing the judges of the concerned state high court. Whenever a state high court judges or chief justices are appointed, we know that there is a collegium to determine. However, to a particular state, judges are being appointed, president will consult the respected governor to say, okay, I am going to appoint this person, hope he has a very clean image, he is not partisan, he has a very good conduct and background history of being a very good judge. He consults the governor because again the smooth functioning and there should be a balance, tight balance between the three organs, executive, legislative and judiciary. Hence, president thinks that it is important to consult the governor, who is the fountainhead of the state, for the better functioning of three organs of the government at the state level. He makes the appointments, postings and promotions of the district judges in consultation with the state high court. He also appoints the persons to the judicial services of the state other than district judges. So district judges, he will do the appointment, transfer, etc. in consultation with the state high court and state public service commission. District judges, he consults the high court, so and so he needs to be transferred, he's better, he's good. No, there are lot of allegations against him, so he needs to be transferred. District judges. Apart from district judges, he also appoints, he also takes the recommendation, he consults the state public service commissions, because certain judicial positions, posts are through the competitive exams, through the public service commission exams. Therefore, he consults both this and the high court. By and largely speaking, governor has an important position in the constitution and his powers are similar to that of president, but president will have, of course he will have the upper hand and more powers. Largely we can compare it with the president, and we can see when I said that the diplomatic powers, military powers and certain discretionary powers, certain times he can direct the Supreme Courts regarding certain cases, wherein governor cannot go to the Supreme Court, seek the regarding constitutional matter and other matters. Whenever it is there, he will transfer the case to the president, seeks his advice. President may, if he thinks fit, he will transfer the thing to, he will ask the Supreme Court judges, Supreme Court to give the advice. So like that. But ultimately you should understand, governor, that office, even though if it is independent, even though it is constitutional office, it is being appointed by the president, who is the fountainhead of India, who also is the first person of this nation. Therefore, he will certainly have a broader functions and roles and powers. But when we look both president and governor side by side in the parliamentary democracy, in the parliamentary setup, parliamentary democratic setup, Both have their own importance and both play a very vital role. And of course, as I said, President will have the more powers. That doesn't mean that office of the governor is or not having any high responsibility. It is not true. When it is about the forming the government, imposition of president rule, when it is about stopping the unwarranted bad bills or to effective functioning of the state, governor's roles are always important and major. When we can compare both president and governor with regard to different bills, financial powers. Certain bills, you see, governor transfers the bills to the president, whereas president has no such, he doesn't have that facility to transfer it to somebody because he is the head. Either he keeps in the pocket, he returns, or he rejects. Whereas governor has the fourth option to send that bill to the president for the consideration. Union Council of Ministers will take a call on that. Discretionary power. See, constitutional position of the governor is very important. It is also essay-based understanding. Throughout past 1.5 hours, I have tried to explain the various functions, importance, roles, etc., of the office of governor. Similarly, the position of the governor is very important. His discretionary powers are limited. However, he has to act on the advice of the Council of Ministers. Articles 154, 163, 164, because from 153 to 167, the articles of the Constitution speaks particularly about governor. These articles 154, 163, 164 are: the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through the officers subordinate to him in accordance with his constitution. With this constitution. This is the article 154, where the positioning of the governor has made very particular, very impertinent, very important. Governor itself is saying that, Constitution itself is saying the executive power of the state can only be, without the governor there is no executive power. Enjoyment of execution of governance starts and ends with governor in the state. Article 154. Then Article 163. There shall be a council of ministers with the chief minister. Similarly, the Article 74 at the center, there shall be a council of ministers with the head, like Prime Minister as the head, to aid and advise the President. 163 states there shall be council of ministers and CM will head it to aid and advise the governor to perform his functions, except in so far he is required to exercise his functions in discretion. Whenever he is about to take the calls with respect to discretion, governor will take every decision on the advice of Council of Ministers only. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. This provision is the foundation of parliamentary system of government in the state. Article 164, important. Article 75, in case of parliament. 164, in case of assembly. That Council of Ministers, Council of Ministers are the club of elected members who enjoy the majority, and out of which the very foremost or topmost brass of those members who form the part of the government under the leadership of Chief Minister, they are the Council of Ministers. These Council of Ministers enjoy the power. They have the collective responsibility to the assembly, where they need to, whenever asked, whenever the no confidence motion is passed, or whenever there is no confidence in the government, they need to prove their confidence. They need to show their numbers, simple majority. Otherwise, the government will fall down automatically. That responsibility, because see, once you get elected and you do not have the responsibility towards the assembly, in that case, it will become a dictatorial form of government. To ensure that this is not dictatorial, this is parliamentary democracy. Therefore, even if you have enjoyed the majority once, that doesn't give you a complete freedom to rule for next 5 years. Every time you need to prove your majority in the well of the house. And that is where your real responsibility lies. If you get the majority, it doesn't mean you can do anything you can do. No, you are answerable, whether it is about the budget, whether it is about your conduct, whether it is about your acts. Everything has to be answered in the well of the house. That is where your responsibility lies. And if the CM resigns, automatically the Council of Ministers will fall down, will dissolve. So 164 is also the foundational aspect for the parliamentary form of democracy in India. From the above, it is clear the constitutional position of governor differs from the president. How? While the constitution envisages the possibility of governor acting at times in his discretion, no such possibility is given to the president. When governor can discretion? Remember, he can invite somebody to form the government whenever there is no proper numbers. He can transfer certain bills to the center, to the president to take a call. This is one of the ultimate discretion which president doesn't have. He can recommend to implement the president's rule whenever the state machinery falls down. Finest discretion, where he is not required to abide by the suggestions or advices tendered by Council of Ministers. After the 42nd Constitutional Amendment Act, that is 1976, Indira Gandhi brought it. It is called as mini constitution because most part of the constitution was edited, amended, and many changes were made, whether it is in respect to emergencies, fundamental rights, fundamental duties, and many aspects were changed. So in the same way, ministerial advice has been made binding on the president, but no such provision has been made in respect of governor. Right. Therefore, right now there is a case in the Supreme Court. Supreme Court says that if the government do not take any call or rejects the bill or withholds the bill, let's say properly, if he withholds the bill, the act will not die. But 42nd Constitutional Amendment has particularly made Council of Ministers advice binding on the president, which is not binding on the governor. That means he is also having the third option, where one, his discretion, that whenever he thinks it is going against the ethos of the constitution or the center or the nation. Second, whenever the governor thinks that certain laws, certain acts are going against the wishes, well-beingness of the people of the state. 3, this is one of the defense, where the governors should defend themselves in the court of law by stating it is very clear that advice of the Council of Ministers is not binding on the governor, at least as far as it is concerned in the Constitution. The Constitution makes it very clear that if the question arises whether a matter falls within governor's discretion or not, decision of the governor is final. Whenever there will be a question on many aspects it will come. Governor cannot act. He has to act and abide by the advice of Council of Ministers. Governor will come and say, no, it is my discretion, where I can take a call, where I can make a decision, where I can transfer the bill, where I can withhold, where I can reject, where I can send back. During such times, the decision of the governor is final and ultimate. The governor has the constitutional discretion in the following cases. As I said earlier, reservation of the bill for particular reason, if it is endangering the position of High Court, whether it is against the nation, etc., etc. The recommendation for the imposition of the President rule, again it is a discretion. While exercising the functions as the administrator of an adjoining union territory, in case of additional charge, determining the amount payable by the government of Assam, Meghalaya, Tripura and Mizoram to autonomous tribal districts, which is not uniform to other governors but only in case of AMTM states, Schedule 6 of the Constitution. Seeking the information from Chief Minister with regard to the administration and legislative matters of the state. He can at any time, that is one of the discretion, any time. In the midnight he can call the Chief Minister and ask, give the information of such and such. Chief Minister cannot say, I have tendered all the information in the morning, why are you calling now? Governor may think, because it is his discretion, that in the evening many changes may have happened. You may have done many changes to the act bill or to the developments. So he can seek the information at any point of time. In addition to the above constitutional discretion, he has also got the situational discretions. It differs from situation to situation. Appointment of Chief Minister when no party gets the majority. Dismissal of the Council of Ministers when it cannot prove the confidence. There is no need for him to give the time. There is no need for him to say, oh, you go and search for other options. You go and search whether outsiders are giving the support or coalition. No, he can dismiss the Council of Ministers at any point of time. Dissolution of the State Legislative Assembly if the Council of Ministers has lost the majority. Again, during that time, Council of Ministers cannot come and say, sir, we still are the Council of Ministers. You please do not dissolve the House. We will try to prove the majority by tomorrow evening. Governor need not to listen to that impractical solution, impractical suggestion. He may directly go and dissolve the assembly. Moreover, the governor has certain special responsibilities to discharge according to the directions issued by the president. As I said earlier, he is head of the state, no doubt, but he is also the agent of the center. That's why he has to abide and follow the directions provided by the president from time to time. For example, in Karnataka we have 371J, wherein it is called as Kalyana Karnataka. 6 districts of Karnataka state, which are earlier called as Hyderabad Karnataka, which were considered or given the special status because of their backwardness. Governor, through his decision can make certain provisions for the development, for the recruitment, reservations from that area, etc., etc. Therefore, the same pattern is followed in Article 371 from Maharashtra, Nagaland to 371J Karnataka, establishment of separate development board for Hyderabad Karnataka region. He may establish, he has, because it's a constitutional mandate, separate developmental board for Hyderabad Karnataka region, right? Thus the constitution, same will follow Vidarbha region in Maharashtra, then administration of tribal areas in Assam, etc., etc. Thus the constitution has assigned dual role. He is a constitutional head of the state as well as the representative of the center. Therefore, the balancing wheel of federalism will rely on the effective functioning of the governor. It is very clear and very simple. Governor has to be a synergetic starter for the smooth functioning of center-state relations as well as the smooth developmental, multidimensional, prospective path forward, way forward, and he has to set he needs to be a red carpet for any state's development. He needs to be a starter. He should never be the obstructionist for any state's welfare, betterment. In the past 75 years, we have seen governors were solely used as the agent of the center to create obstructions whenever there is a different party from that of the center which is ruling the state, to create some sort of tension, obstruction. It's kind of a backdoor politics, negative politics conducted through the governor's office to destabilize the government, to create disharmony, to create tension, to dismantle the developmental process or dismantle the real agenda which a government wanted to establish. This is a bad pattern, bad trend started or continuing till today. However, being a responsible governor and having the discretions, he should also think of the people of the state. Also he should become agent of the center as well as the head of the state. Therefore, he cannot be a partisan person. He needs to be a apolitical person, and he has to ensure the effective functioning of the parliamentary democracy can only be possible because of, or solely because of, the credible, accountable as well as the moral functioning of the governor. Governor office in this regard is very important in the understanding of polity, Indian polity, constitution. His role, responsibility, his positioning is paramount. As I said earlier, for the effective functioning of the parliamentary democracy, the office of the governor, and for the continuous governance, most important, continuity in the governance, to uphold that principle, the office of governor plays an important role to ensure at the state level both the development is going on, state is getting prosperous, or let's take out those words, state is being governed without affecting the unity and integrity of India. No such ideas of secessionism, separatism are built in the state, but a joint form of federal form of unitary government is established, or it is kept with the addition of centers and states friendship. That can only be possible because of the president acting impartial, acting non-partisan, as well as governor acting impartial and non-partisan person who can hold up together the idea of one nation, and also to ensure that there is no tensions between the states and also state versus center. For the effective functioning of Indian democracy, this is the necessity, and we have seen many commissions sitting, Panchi commissions, Sarkaria commissions. We have seen many commissions with respect to many aspects, but whenever the question of federalism comes, one thing or one aspect always mentioned is about the misuse of the office of the governor and requirement of non-partisan, non-political, requirement of an office which tenders the opportunities for the state, at the same time holds up the aspirations of the nation. That's the most important aspect. Every commission has tried to put it, and they have always mentioned through governor there should not be any negative or backdoor politics. Otherwise, the federal balance may fall down, or people's respect to the office or people's devotion, faith in the office may get devioled. We must understand which are the articles we will broadly see the articles relating to when I say 153 to 167, which are about the governor's office, summarizing all these powers and functions and everything. If we look at the articles, we will understand the whole concept of office of governor for any exam to come. So article 153, it says governors of the states. That means there shall be governor or governors. To a state there will be only one governor, but for the states there can be two governor or one governor acting as the governor of another state. But two governors cannot be part of one state, remember that thing. Executive power of the state, who will be the executive? Article 154 says governor is the head of executive. Executive starts and ends, or let's say starts governor, chief minister, council of ministers and advocate general. Appointment of the governor, article 155, which says president will appoint the governor, and also convention is that he will consult the chief minister so that smooth functioning is possible. Article 156 says the term of the governor 5 years or the pleasure until the pleasure of the president. Article 157 says qualification for the appointment as governor. Qualification is very simple. Either you should be a 35 years old and you should be a citizen of India. Then other provisions were made, like you should not hold the office of profit, you should not be a member of parliament or legislative assembly, you are from the outsider. All these aspects were made, provisions were made. 158, conditions for the conditions of governor's office. We all know what are the conditions, we have discussed. 159, oath or affirmation. It is administered by the High Court Chief Justice or the senior most judges appointed by him. 160, discharge of functions of the governor in certain contingencies. Whenever there is emergencies, we have discussed even now the discretions and constitutional, non-constitutional discretions, that is situational discretions. Power of governor to grant pardons and others, we have compared it with that of president. Extent of executive power of a state, until where it can reach out, what sort of laws it can make. It cannot make laws with respect to interstate policies. It cannot bring about taxation policies like that of indirect taxations. It cannot make laws for the Telangana, Hyderabad, Andhra Pradesh. One state cannot make laws for others. That is the provision. Then the 163, Council of Ministers to aid and advise the governor. The mentioning of the Council of Ministers comes one at the level of Article 74, that for the Union President there shall be Council of Ministers. So Council of Ministers are also constitutional posts because they are mentioned in the Constitution. Then the Article 164, other provisions, as ministers like appointments, terms, salaries, etc., they hold the office during the pleasure of the government and they need to show their majority in the will of the house. Article 165, Advocate General of the state, like that of Attorney General at the central level, who is the first law minister who holds the office during the pleasure of the governor in this case. 166, conduct of business of government of a state. Who will do that? Again, governor will decide how the conduct should be. 167, duties of chief minister regarding furnishing of information to the governor. From time and time or whenever governor requests the information, chief minister needs to give it. Then 174, sessions of the state legislature, prorogation and dissolution. As I said earlier, every first session he will go and address, he will dissolve, he will prorogue, he will summon. 175, right of the governor to address and send messages to the house. As I said, addressing my government, he will address every first session of the every year and fresh session of new assembly. Special address by the governor. 176, 200, assent of the bill. Any bill will become act only when it gets the assent of the governor, or when the governor transfers it to the president. Whenever president gives the assent, that will become an act. 201 bills reserved by the governor for the consideration of the president if the bills are against the High Court, integrity of the High Court, against the principle of constitution, against the nation. 213 power of the governor to promulgate ordinances. 213 governor, 123 president. 217 governor being consulted by the president in the matter of appointments of judges of High Court. We have discussed this, High Court judges. 233 appointments of district judges by the governor, and then 234 appointment of persons other than district judges to the judicial services of the state by governor. To different judicial services, how he needs to be appointed. Again, there is a mentioning of he needs to consult the High Court and state public service commissions. So this is all about the office of the governor, which is important office in the parliamentary democracy, also in the federal form of government, which also requires to uphold the idea of unitary pattern of the government, which is very clearly mentioned, or which is clearly, the constitution in itself is focused towards unitary form of government, at the same time federal in nature. The article 1 of the constitution, which in itself states that India, that is Bharat, shall be union of states, not states union. That means it believes in the idea of one union. The concept of federation is nowhere mentioned in the constitution, nowhere. But we say the fiscal federalism or political federalism, parliamentary federalism is an important concept of Indian democracy for the healthy functioning and healthy upholding of the ethos established by our ancestors post-independence, the nation builders, and then envisaged in the constitution itself. Therefore, the office of governor as the head of the state and agent of the center makes very clear distinction from the offices of the president and other constitutional offices. However, as the head of the state, the primary goal of the governor is to ensure the smooth functioning of the governance of the state and to uphold the interest, well-being of the state members. At the same time, as the agent of the center, it is his responsibility to ensure the constitutionality is established in the state. Nothing goes against the constitution and against the nation. As well as a governor, he has the important function because he is the head of the state. Even though if he is a nominal head of the state, that doesn't make him the rubber stamp in every aspect. That is what many commentators call it, rubber stamp. I am not trying to call it. But he has also got constitutional and situational discretions which make him diverse, multidimensional, as well as a pragmatic position in the parliamentary form of democracy. Therefore, the office of governor, India followed as the continued legacy. We could have changed, even today we can change the nomenclature as well as the whole concept of governor. However, draft constitution believed in, they believed in the idea of governors being elected, getting elected. But through the discussions and deliberations and finally in the constitution, governor's appointment was made as the norm for the democracy and for the nation. Hence, even if we followed that colonial office as the governor prior to independence, every governor was a British officer. Post independence, our own governors were there, but certain times governments felt that okay, some outsider has come, he is not willing or he is here to create tension and obstructions. Most of the times governor's office was not seen with good spirit because of the politics played by the central governments. Let it be. India did not follow the governor's office model from that of United States of America, which gets elected. We followed Canadian model of governorship, who are appointed, not elected. The governor's office is most important office in this regard for a healthy democracy, parliamentary setup, and also the balancing wheel of federalism can be achieved through the agents of the center and head of the state called governor. Their effective functioning as well as wisdom should lead the way of the state governments, as well as remain well connected with the well-being of the people, as well as with the idea of one India. Therefore, the governor's office, even though it may seem very idealistic, but in practicality, when it is about the pragmatism, it has its own importance to play, and in every exam, governor's office will remain a cherry-picking question, both for the reason it is very easy concept to understand, and sometimes it is tricky, like who appoints the chief secretary. There was a question in UPSC. It is for you to answer that question. Few years back, that was the question in prelims. It is also related to governor because one of the option was governor, chief minister. Who appoints the chief secretary? The question is in your court. Please do answer if you have understood this whole concept. You may get back to any of the constitution book, Subhash Kashyap, or Indian polity books, and refer to chapters and try to analyze what I have tried to discuss over here. It is nothing new. I haven't made up any points, but they are the points which are there already in the book. Any book you can refer, any notes you can refer. These are the basic and broad ideas and dimensions we should have with respect to governor. Once we understand this whole concept altogether, there is a ever-evolving debate or ever-evolving news, ever-evolving some sort of issue with respect to governor's office. Every time there will be, every time. Now it is in the Supreme Court. Supreme Court has said that obstructing, every time government coming to us to give the nudge to the governors to pass the bill or take an action is not good, not in the good spirit. That is the observation what they have made, and they have said that if the governor withholds the bill, that doesn't mean the bill gets rejected. So we need to read between the lines. There is a lot of politics and there is a lot of judicial activism behind this. At the same time, governor's activism also sometimes may not be seen in the good taste. However, governor, as I said earlier, is the important cornerstone of balancing wheel of India's federal system, India's unitary system, and it is required for every common man and also any aspirant to understand governor thoroughly. At the same time, understand the governor while keeping president side by side. Only then two officers can be understood, unleashed without any confusions, and also we will be able to understand even if president appoints the governor has certain situational discretions which are different from president, and president has more power. Even then, governor's powers are unique than that of the president. So governor position, governor's office, governor's functions, roles, everything we studied from article 153 to 167 of the constitution. Hope this video was useful. Please share a word and do write back to me regarding the discussions we had till now. Hope this was useful. Dhanyavada. Jai Hind. Thank you for joining me in this live session, live class. Hope this was useful. If it is useful, I'll try to continue to do more and more free classes on this platform itself. Great day. Study well. All the very best. Hope this was explained in very simple terms so that every common man could understand. At the same time, every aspirant was able to relate, revise, and to understand from the scratch till the depth and till the heights of this concept. Thanks a lot. Namaskara. Shreyanka Saranade. ಜೈ ಹಿಂದ್.